Hey, honey, I know you mentioned something the other day. Did you want to go ahead and get your will done?
Oh no, we've been together 6 years now. I'm his common law wife, so we don't need wills because I'll get his money anyway.
Hey, Lauren, have you gotten your LPA sorted yet?
No, it's fine. I've just told Charlie that if it comes to it, then he can just make my end of life decisions for me. So I think I'm sorted.
Did your parents still want to chat about their LPAs?
No, so we've just chucked it all in a Word document. Don't worry, I used my law degree from 10 years ago. I helped them write it. We put dotted lines, everyone signed it, we all watched each other. So it's like totes legit. We don't need you anymore. Thanks so much though.
Have you thought about protecting your business?
Oh, no, it's fine. My mum would just tell all my clients I'm dead, so it's fine. No bother.
Hey, y'all, I'm Cece. I'm the owner of Brilliant Estate Planning, and I want to talk to you guys today about the dangers of DIY estate planning, like wills and LPAs. These are legitimate things that I hear sometimes. Obviously, I'm taking creative liberties to make it a bit funny, but these are things that I hear from people and it concerns me. So I just thought that I would make this little silly video, but also inform you of the possible implications of not going to a certified estate planner when doing your planning, and what issues might arise and what problems your family might face in the future so that you can make an informed decision. Number one, you get what you pay for, right? The old adage is true. I'm sure you found it living your life as an adult human. So, if you go someplace and you just get, one of those 15-pound fill in the blank wills, or you do one of those online services where you don't get any advice, um, then you don't necessarily know the implications of your decisions. You've not had anybody walk through your concerns with you and how to address them, and you might think that things are addressed that actually aren't, because one little line and clause in your will sometimes can make all the difference. So it's important when it comes to this kind of stuff to make sure that you get the proper advice so that you have the proper planning that you need so that all your concerns are alleviated and your family is protected. Because especially when we're talking about wills, it's not for you. You're already dead. It's for the people that you leave behind. So let's make sure that your family doesn't have a mess to deal with. Number two, there are tax implications for some decisions that you might make. There are sort of like tax relief thresholds called the nil rate band and the residential nil rate band for inheritance tax purposes. And if you leave different legacies in your will or do different things with your money or leave certain things to certain people that are outside your direct line of beneficiaries, those people may not be able to get that inheritance tax relief and then have to pay, the 40% inheritance tax rate on something that you've left them because you left it in the wrong way or to the sort of wrong person or whatever. There are ways that you can that you can do these things, and get a little bit more creative so that what you want to happen still happens, but in the most tax effective way. Number three, there are even pros and cons to naming your children individually in your will, and in your estate planning, because it might be better to just have a line that says my children. If you're a young family and you're just starting out and you just have one kid and you maybe are looking to have more and you don't want to, change your will next time, you want it to be good for the next, 5 to 10-ish years. Well, you've only named one child in your will, and then you have another one, and you have like your guardians and everything set out for the first one, but you don't update your will for the second one. And then what if something happens to you? Your other child isn't named in your will. That could cause some problems. So it depends on where you are in your family stages as to whether one thing or the other might be better for you to do, in which case it's best to talk to an estate planner and take advice. 4, I put additional clauses and things in your LPAs. I make sure that you name the right people. I make myself your certificate provider. So I sit there and I sign the LPA and say that I'm a certified estate planner. I've worked with you and all these things. I also can provide a will clarity statement that goes with your will that says that you are of sound mind, all these things. 2 and 5 wills are contested now. It's just going up. I speak with contentious probate solicitors all the time and get advice from them on the best sort of policies and procedures to put in place to make sure that you're protected if anything were to happen, if anybody were to contest your will. It's a real thing. People come out of the woodwork. I've experienced myself, loss either brings out the best in people or the worst in people. And it's good to make sure that you have this stuff already, because by the time people contest your will, it's too late for you to speak for yourself. So you need to make sure that everything has been laid out. What you want is protected and not overturned. Number 5, not having trust advice can leave you vulnerable to care fees, creditors, bankruptcy, divorce, marriage after death, all kinds of things. Say you're leaving your estate to your husband, you have kids, and then you leave everything to him, and then he remarries, and then they leave everything to each other, and then he passes away, and now all of your money that you left for him to go to your kids is now diluted to his new wife and her kids, or their kids they have together, and this whole new family that you never even met. And you probably want your stuff to go to your own family rather than people you've never met. Well, if you left all that stuff in a trust instead, then it would be protected. And it would also be protected from, if those kids got married and then divorced, that money would be safe in trust for them. If they had to deal with any creditors and bankruptcy, that money would be protected. There are all sorts of reasons that you might want to look into trust planning, as well as if you have disabled beneficiaries. It can be important to leave things in trust for them so that they can make sure that they're still able to access the help that they need, and also to make sure that people that you trust are in place to help them look after their money, because people take advantage, and you want to make sure that your family is safe. And this is the kind of advice that you're not going to get from just a DIY or just a standard will. Okay, number 6, and the last thing I want to say is just that you don't know what you don't know. If you don't realize that something is a misconception, then you don't know to ask the question, is this wrong? You just think because we're married, everything will go to my spouse, even though that's not necessarily the case. Or you think just because you get divorced, that your will is null and void and your ex won't get anything. And that's not true. Divorce doesn't invalidate a will. So if you don't write a new one, everything still goes to your ex. These are things that people don't know. And if you don't speak to someone who does this kind of thing for a living, then you wouldn't even know that that's an issue. This is why I do these informative videos and why I talk to all my clients about their concerns, etc., etc. But it's so important that you get the proper advice. This is why you hire a solicitor to deal with your land registry stuff. You hire a mortgage advisor to deal with your house stuff. Your estate planning is arguably the most important financial planning that you can do, because you look after yourself if you were to lose capacity, to have any sort of accident, any sort of healthcare and financial decisions that you might not be able to make, or you might just allow somebody else to make if you're not there at the time or whatever. Your will stuff is for your family. Who wants to be grieving and decide whether their family member wants to be buried or cremated, or what songs they might want played, or what flowers they might want, or if they would want donations made to a charity. Do they want to go through the whole probate process and have to get all this extra paperwork, maybe hire a solicitor because you passed away without a will? Make sure that your family members who you want to inherit do. and not necessarily your third cousin who came out of the woodwork and put a claim against your estate, right? This is such important stuff. You want to make sure that you do it right and you do it well. So whether you work with me at Brilliant or not, whether you work with someone else, I don't mind. I just want you to be safe and protected. So if you have any questions about this or anything else, please do get in touch with me. I'm more than happy to have a chat with you. There's absolutely no obligation for my consultations. I can provide you with all my recommendations of all the stuff you can do, and then you can make an informed decision of what is best for your family. Thanks so much for watching. I'll see you next time. Bye.